Good afternoon, ladies and gentlemen. Professor Kammerer, Professor Pedro Barbas Homem, Professor Maria João Estorninho, Professor Vasco Pereira da Silva, ladies and gentlemen, on behalf of the Faculty of Law, I am pleased and honored to welcome all to this 16th Congress of SIPE, a prestigious association of European public law scholars. I salute everyone present here in the premises of the Faculty of Law, but also those that follow us online. Allow me to thank the Portuguese organizer and scientific coordinator of this event, Professor Vasco Pereira da Silva, always enthusiastic and profoundly committed with the relationship between the faculty and European and international organizations, scientific networks, and projects. In addition, I want to thank the Erasmus Office for their hard work all year long, and especially on this occasion. This international conference will allow us to hear many distinguished speakers sharing their views on the theme, New Public Tasks in Times of Tension. The theme, a theme that encompasses diverse aspects such as climate and digital transition, global and national health concerns, within a background of war in Europe. It is a very challenging program and surely a very interesting event. Thank you. Thank you for being here at the Faculty of Law, and thank you very much for your attention. Now I pass the floor to the next speaker, which will be, yes, Professor.
Boa tarde a todos. Apenas umas breves palavras, primeiro em português, para saudar todos e, em especial, também agradecer a escolha da Faculdade.
Thank you very much. Now, Professor Maria João Estorninho, you have the floor.
Thank you.
Now, Professor Kammerer, please.
Madame la doyenne, Monsieur le Président du Conseil scientifique et Madame la Présidente du groupe des professeurs de droit public, estimadas senhoras e senhores, Mesdames et Messieurs, ladies and gentlemen, meine Damen und Herren. I will speak in 3 languages and maybe a little Portuguese interspersed. Als Präsident der SIPE heiße ich Sie alle sehr herzlich willkommen und ich freue mich, dass Sie alle der Einladung der SIPE und der Fakultät gefolgt und zu dieser Veranstaltung gekommen sind. Bei manchen ging das mit der Metro und manche sind mit dem Flugzeug über weite Teile Europa hinwegs gekommen. Ich danke sehr der Fakultät, in deren Räumen wir tagen dürfen, für ihre Gastfreundschaft, ihre Unterstützung in allen Dingen. Ich danke Vasco Pereira und seinem Team für die exzellente Organisation und alle Arrangements darum herum. This is the 16th SIPE Congress, and it's being held 20 years after the SIPE was founded in Frankfurt. What does this mean? This means that we cannot evade any longer talking of or about, depending, tradition. What is tradition? When does tradition begin? And has the SIPE been successfully establishing a tradition? Etymologically speaking, tradition derives from Latin tradere, handing over. So it's an intergenerational thing that involves preservation and evolution at the same time. In the positive, tradition reflects reliability, trustworthiness. In the negative, it can amount to immutability and incapacity to reform. When the Austrian emperor once complained to the composer and conductor Gustav Mahler that his way of performing music was not in conformity with tradition, Mahler purportedly, se non è vero e ben trovato, replied, was Eure Majestät Tradition nennen, ist nichts als Schlamperei. Une phrase pour laquelle il n'y a probablement pas de traduction exacte ni en anglais ni en français. Sloppiness, négligence, c'est pas le même temps. Quant à la SIPE, cette traduction, encore jeune, n'a, j'espère, pour le moins rien de tout ça. L'atelier des jeunes chercheurs qui va débuter dans un instant est emblématique de l'échange entre générations qui caractérise la tradition. En même temps, ce congrès est marqué par cette fiabilité qui est aussi intrinsèque à la tradition. C'est la deuxième fois que l'Université de Lisbonne organise un congrès SIPE et comme en 2011, notre hôte et organisateur est le même, à savoir le professeur Vasco Pereira de Silva, auquel la SIPE est très reconnaissante. Tradition heißt Weitergabe, aber auch wieder anknüpfen. Wenn eine wissenschaftliche Vereinigung eben zum 2. Mal an einem Ort tagt wie heute, dann ist das ein Zeichen von Traditionsbildung. The general theme of this Congress, which Vasco also conceived, is in itself closely related to that theme of is closely related to tradition, insofar as it rests on the assumption that new challenges exist that entail new, that is, somewhat non-traditional public tasks. Public tasks, for that matter, not just tasks of the state. This is not the place and time to enter the old debate on whether intrinsic core functions of the state exist, or whether the functions and characteristics may change over time. Drawing a list of allegedly unalienable core functions of the state, as some courts are indeed inclined to do, may block the view on the needs and challenges and the question that must always be raised in this context. Can they still be tackled by a single sovereign state? Even more so, can this be the case in times of tension? In other terms, Panta Res spares neither the state nor the concept of sovereignty nor the functions associated with it. Damit will ich es bewenden lassen, um nicht Vorträge und Diskussionen ungebührlich vorzugreifen. Ich wünsche uns allen eine schöne, inspirierende und ertragreiche Tagung in bester Tradition unserer wissenschaftlichen Vereinigung. Dankeschön.
Well, ladies and gentlemen, dear guests, we are in the opening session of our 16th SIPE Lisbon Congress. This is a kind of a special annual party because it means that we have the opportunity of meeting again after last year's meeting in Luxembourg, talking to each other and discuss our scientific stuff. As president of the Erasmus and International Office of the Law Faculty of the University of Lisbon and member of the executive committee of the SIPE, I am the organizer of the event. So I am expected to act like the owner of the house and do the honors. I believe that the duties of a good owner of the house are as such: say hello to the guests, show them the house room by room, and wishing you all to enjoy the party. Clarify the situation, I have now to fulfill my duties. First, to say hello and welcome to all the guests, and thank you for your visit. First of all, I'd like to thank to the Dean, Professor Paula Vaz Freire, the President of the Scientific Council, Professor Pedro Barbas Homem, the President of the Group of Professors of Public Law of the Faculty, Professor Maria João Estorninho, for all the support they gave to us in the organization of this Congress. Then I have to say hello and thank the colleagues, members of SIPE, coming from different countries of the European Union to participate in this 16th Congress. Then the Portuguese colleagues that are taking part of the event. And last but not least, I would like also to thank my staff, the Erasmus and International Relations Office, namely my colleagues of the Board of Direction and the administrative staff, Mrs. Andrea Caeiro and Mr. Miguel Pires. Without them, it would be impossible to organize such an initiative. Two, I have to organize the guided tour through the house, showing to the guests our 5 rooms. We have 5 rooms, not 4. And these 5 rooms include the workshop and the other 4 thematic sessions, because we are discussing on the 5 new public tasks in times of tension, as well as our 2 living rooms, the opening and the closing session, and our garden cabinet, which is the social program that includes 2 lunches on Friday and Saturday at the faculty, a dinner at the Jockey Club on Friday evening, and a visit to the City Museum on Saturday morning. And the idea was that in these 5 rooms, we could discuss the main topics of the new public tasks of today. And for that, we have to talk about digitalization or digitization. We have to talk about defense and security. We have to talk about health. We have to talk about climate change, and we have to talk about energy and energy policy. That's the idea of putting together these topics that arise from international texts, arise from the treaties, arise from the Constitution, and as a matter of fact, as we'll see in the end, they are all united as public tasks of nowadays in times of sessions. Finally, I have to wish all the guests to enjoy the party and feel like coming back again very soon. That's it. Let's party. Thank you very much for your attention.
Thank you very much, Professor.
Now I call for the members of the first panel in order to begin our works. Yeah. Thank you very much.
Obrigado, Rui. Two areas of dissonance. Class action rights can be seen as an example. Portugal can be considered a very generous country in terms of class action right, class action framework, class action rights. Article 52, paragraph 3 of the Portuguese Constitution constitutionalizes class action right, including for compensation of damages granted to all individuals, associations representing interests, namely in the areas of public health, consumer rights, quality of life, preservation of the environment, cultural heritage, among others. Class Action Act or Class Action Law enacted in 1995 implements this legal regime, the conditions under which the legal regime can be exercised. Recently, a new controversial piece of law, the Portuguese Charter of Rights in the Digital Area, has adopted a new type of class action, a digital class action. It establishes a digital class action adapted to the reality of the digital environment and also adopts a certain number of rights, including against digital platforms. And of course, the GDPR. The GDPR being directly applicable in the Portuguese legal system through its Article 80 grants the right to mandate a not-for-profit body, organization or association constituted in accordance with the laws of the member states, laws of Portugal, active in the field of data protection, also to exercise the right to a judicial remedy, including the right to seek for compensation of damages. Now, some serious legal doubts remain. Right to class action is meant to be a tool for enforcing community interests, to obtain judicial protection in defense of a certain number of constitutional or legally collective goods or rights or interests of a supra-individual nature. And the Portuguese law, the collective plaintiff represents on his own initiative and without the need of an express mandate or authorization, all the holders of interests or rights identical to those he intends to enforce in court. It is precisely in the context of this legal standing, this legitimacy, the defense of community interests and not personal interests, that the widening of the class action legitimacy must be understood and interpreted. That's also the reason why Portuguese law adopted some very exceptional rules that contribute to the design of the Portugal system of class action rights. And these are, among others, first, the establishment of a representative regime based on an opt-out system without the need of a mandate. And secondly, the fact that the result of a class action will typically impact on the legal sphere of third parties. As I was saying, our regime is a representative regime based on an opt-out system in which, unlike the effects of res judicata extended to all persons belonging to the represented class, with the exception of those that decided to exclude themselves, as you can see, there's an extension effect for those citizens. Now, and here is my first doubt. Specifically, the recent trend for using litigation funding mechanisms by for-profit entities, specifically in action for damages, and the identification of other situations. These situations may be more or less subtle, may be potential, may be actual, situations of conflicts of interests. Foreign to the represented class are circumstances that should cause courts to be especially vigilant. Courts should be especially vigilant and raise the levels of preliminary scrutiny on how plaintiffs effectively fulfill the requirements for the attribution of class action legitimacy. A different direction would make class action rights particularly vulnerable to abuse, which is not compatible with the notion of defending the rights of a community or of a class. Second issue. While neither the Constitution nor the 1995 Class Action Act have, of course, anticipated such developments, we are now witnessing the rise of privacy class actions, including, I would say, the rise of class action rights in Portugal. We have a few now, and this will increase precisely because of the generous framework we have in the country, the legal framework we have in the country. Privacy class actions of this sort pose an additional concern. Of course, privacy class actions must be also assessed in light of the GDPR, particularly Articles 80 and Articles 82. If you read Article 80, this norm allows one to conclude that the legitimacy of non-profit bodies, organizations, or associations to act in the name of the data subject in actions for damages presupposes, as a rule, the existence of an express mandate, as provided for in Article 80, paragraph 1 of the GDPR. Paragraph 1 lays down specific rules for the judicial protection of data subjects with regard to the protection of personal data, giving them the right to mandate a non-for-profit body, organization, or association whose statutory objectives are in the public interest, covering the protection of the rights and freedoms of the data subject. Article 80, paragraph 2, in turn, admits that the member state may provide that the non-for-profit body, organ, or association may act without a mandate to protect rights relating to data protection, except for, however, actions for damages provided for in Article 82, that is, excluding those actions intended to compensate for damage caused by civil liability. Which means that in Article 80, paragraph 2 of the GDPR, no genuine collective redress of non-individual interests of data subjects is foreseen at the outset. It only provides for the possibility for member states to introduce individual protection of such rights, although exercised by third parties without a mandate. Now, there's a, I know that we have time constraint. There's a legal debate, of course, about which types of privacy damages and harms are in fact compensable. There's recently an Austrian Post case. As you may know, the ECJ held that the mere infringement does not automatically give rise to damages that must be compensated. That means that the plaintiffs under Article 82 of the GDPR are expected to demonstrate the existence of an infringement, actual damage, causal link. But the exclusion set out in Article 80, paragraph 2 is understandable. Article 82, paragraph 1 of the GDPR on the right to compensation and liability provides that any person who has suffered material or immaterial damages due to the breach of the regulation is entitled to receive compensation for the damage suffered. But the damages that may be suffered as a result are produced in a different manner and with a different scope for each one of the data subjects, since privacy claims are inherently individualized. And this is important in two senses. Procedurally, class actions may, because of this, be considered non-admissible to the extent that those who suffer negative consequences, damages, will depend on each individual case. This may be used to sustain the existence of commonality on the claims, and therefore to this class action right. On the other hand, it is also quite understandable that in general, compensations for damages resulting from breaches of the GDPR, the European legislator has excluded the possibility for a third party, a non-for-profit body, an organization, an association to claim such compensation when it does not have the express powers conferred by each injured party. Question: it remains to be seen how this interpretation of Article 80 in conjunction with Article 82 of the GDPR actually articulate with the opt-out system adopted by Portuguese class action law. It remains to be seen. Second development. 3 minutes? 2 minutes. Second development, privacy injunctions. There's a recent fascinating decision by the Lisbon Court of Appeals in Lisbon, the Wikipedia case. Mr. César do Passo, a Portuguese businessman living in the US, living in Portugal, with some public visibility as an honorary consul, filed an unspecified injunction against Wikimedia, asking that the proceedings be granted, and Wikipedia was ordered to immediately block and shut down 2 web pages hosted on Wikipedia containing biographical data. Mr. do Passo claimed violation of his good name, honor, images, because the pages contained false facts, insinuations, instigations. It offended his name, his reputation. It alleged that he was financing a new populist party in Portugal called Chega. He was, of course, very upset with this. Now, typically, this would be a very traditional case, conflict between personality on the one hand, freedom of expression on the other hand. And in fact, the Court of First Instance, it precisely approached the issue as a very common traditional conflict between these two sets of rights. The Court of Appeal reversed the decision, and the Court of Appeal decided to frame the case within the scope of the GDPR. Mr. César do Passo had introduced in the proceedings the argument that Wikipedia had to comply with the right to be forgotten. And the Court of First Instance first confirms the first instance decision that the Portuguese courts were internationally competent, which is also something that is also important, but we don't have time to dig into that. It considered that the authors of the publication in Wikipedia had to be identified for a future action for civil liability. It held that Wikipedia and the authors of the pages are joint controllers for the perspective of the GDPR. They probably have no idea, the authors of those pages, that they are considered as controllers. They are controllers because they determine the purpose and means of the processing of personal data. And because of that, and also the content of those 2 pages can be considered a form of journalistic treatment. A form of journalistic treatment, because Wikipedia is a collaborative project. Wikipedia is a form of journalistic treatment. And in this regard, the court aligned the decision with a very important case, recent important case from the European Court of Human Rights, the Buivits case, where a Latvian citizen I know, 30 seconds, where a Latvian case has decided to film the interrogation by 2 police officers and published it on YouTube. And what the court has decided in that case, the European Court of Human Rights, it said he had the right to free speech, but specific measures, data protection measures, had to be adopted. Now, if we had the time now, but we don't have, if we had the time now, I would here develop how free speech rights and privacy rights should be articulated. And I think this is a fascinating case, a fascinating relationship. And the balancing between, under Article 85 poses indeed very complex topics. Unfortunately, I don't have the time now to do that, but certainly this is a case where the court, in the Wikipedia case, decided that with respect to those defamatory and false pages, there was no proof that this person, this businessman, had indeed financed that political party. No factual truth about his specific involvement in criminal activity. And because of that, the court decided to uphold the right to be forgotten. Because of that. We'll stop here. But I had more.
So sorry. So as a chairperson, so thank you
I'm sorry,
very much for your presentation, sir. But
Sorry.
we are looking forward to the written version,
Okay.
where we can read all that.
Absolutely.
So as a chairperson, one is always the timekeeper, and that's a very unfortunate position. So, but thank you for your very interesting insight into the chances and intricacies of class action and the room for action that's given by the GDPR for that, and what Portugal does in this respect. So, without further ado, I'll pass to Eloisa Maria Perez Conchillo, who's a lecturer at the University of Granada. Her doctoral thesis covers transparency and the right of access to public information. And she's currently acting as an interim professor of constitutional law. I hope that information is still topical. So you're professor of constitutional law at interim.
I am in the process, yes.
Yes. Okay. So the topic you're talking about will be very close to doctor thesis, namely the right of access, but now it's getting more digital than the other topic. The right of access to digital information in the digital society. You have the floor.
Thank you, Professor, for your presentation. First of all, I would like to thanks to the direction and the organization of the SIPE Congress for all the effort they have made to make possible this event. And of course, thank you for having me in account to participate in this workshop. Thanks also to the Faculty of Law of the University of Lisbon for hosting us during those days. Well, I am going to share with all of you some reflection about the right of access to public information in the context of the digital society. And to do this, I will first contextualize the scenario in which communicative freedoms are developing in the digital age, since it must be taken into account that the communicative process is being absolutely determined nowadays by technological advances in the information society. In the global context, information flows through internet in a different way to the analog context. If we compare and if we take in account the constitutional doctrine on freedom of information as classically developed. Information on the internet is anonymous, rapid in dissemination, immediate in reception, massive and dispersive. And all such nodes have favored new pattern of social behaviors in the society, especially through the popularity of social network with the internet as a new means of communication. In this sense, we are witnessing an alteration in the communication process that is reflected both into pillars, in my opinion, the subject and the medium in which these freedoms are developed. On the one hand, the active subject that informs, it's no longer only the media, because now the communicative paradigm is shared with the citizenship. Thus, the typical role of social watchdogs traditionally given to the media is fragmented in order to contemplate now an informed citizen as well. Consequently, the passive subject that had been identified traditionally with a citizen as a mere passive receptor has also changed. Citizens no longer wait passively to receive information produced by third parties, but in addition to being able to disseminate information, take an active role in the search of information. On the other hand, the medium for the exercise of communicative freedoms has taken a qualitative leap. In this way, there has been a swift away from traditional means of social communication, such as radio, television, or the press, in favor of digital platforms, where citizens exercise now their fundamental rights, or large part of them. This change is causing a problem, a big problem from a democratic perspective and in a constitutional perspective, because as we all know, the essential pillar of constitutionalism is the control of power. And traditionally, this power has been understood as a legitimate power wielded by the state. But nowadays, digital platforms exercise a large part of this power. So that today we are experiencing a process of fragmentation of the public sphere. And this cannot be addressed in the digital context as it has traditionally been done until now. The role of the state in the analog context was clear, and with it also its ability to guarantee fundamental rights. However, the separation between the public and private has become blurred, more difficult. As can be seen from the example of the social networks, it's a private space that it's now under democratic rules, but it has nevertheless become a new space for public debate and for exercise of rights. So we can ask ourselves the same question, the next question. Can or should digital platforms be considered today as a new public space? This is a current issue that the Spanish Constitutional Court has decided in a negative way. In Judgment 27 in the year 2020, the Spanish Constitutional Court considered that the digital environment is not comparable to the concept to public place. And in my opinion, this view is open to criticism. Since it's difficult to speak of a democratic reconfiguration of the public space update to the digital context, if this public space remains reduced by the parameter of the analog context. Indeed, digital platforms are powerful private companies that operate in global market, as we know, on basis of their own interest, economic interest. But however, it does not prevent us from recognizing that in practice, they have become new space for the debate, open to society for exercise their rights. And in this way, the platforms seem to be a territory where public and private tasks are confused. It's precisely on this line that separate the public and the private, that one of the great challenges of contemporary constitutionalism lies, which must be orientated toward providing the state with mechanism to guarantee rights wherever they are exercised. In this line, we have to take note of the fact that all state work relating of transformation, global, local, national, regional, public or private powers must be seen through the prism of democracy and rights of individuals. This background serves to underline that in contrast to the weakening of citizen as subject of right in the face of deregulate private power, another reading is possible in terms of the relationship with public power. And from this perspective, it makes sense to analyze and strengthen the democratic role of the right of access to public information in this digital context. This right, together with the principle of transparency, should be understood as constitutional mechanism that at the service of social and democratic rule of law, without prejudice of the fact that within the framework of current constitutionalism, the debate on the control of power that underlies the digital medium may arise. There is no doubt that today citizens have greater access to information, but paradoxically, they are not better informed. And this has to do with the democratic deficits that underlie the dialectic of how works the social networks. And in this sense, the regression that the pluralist conquest of decision and making is suffering due to the great influence of private agents who participate in the public sphere without transparency mechanism is worrying. As Professor Balaguer has explained, state power has been reduced in the fragmented decision-making space, thereby also dispersing part of the democratic pluralism that the state has traditionally been able to guarantee as an inherent element of the democratic principle. Currently, pluralism and freedom of expression and information are being affected by the phenomenon of disinformation, fake news, polarization, and other factors whose common denominator is manipulation of information. In all of these, public policies of transparency and access to public information becomes relevant as mechanisms that reinforce the democratic principle and the rule of law in the digital society. And this statement, this vision is justified by the fact that by one hand, the principle of transparency acts as a prerequisite of effective participation in the public life and promote public confidence to the citizen. And this principle justifies the rationality of action of the public authorities and thus confirms that the public authorities act in accordance with the rule of law. In my opinion, it's possible to affirm that democratic principle is undergoing a constructivist process in the global information society, in which transparency is played as a key defining element. Thus, democracy can be contextualized as the control of power through the decision of the majority with respect for minorities, but underlying the need for public power to act transparently in the framework of the information society. And by the other hand, the right of access to public information strengthens the position of citizens in their relationship with the state in a democratic decision-making process. Taking the Spanish example as a reference point, we should mention the paragraph of the Article 20, letter D of our Constitution, because in this article, the Spanish Constitution guarantees the freedom to communicate and receive information at the same time. However, the constitutional doctrine in Spain on these freedoms has not evolved very much because it had not yet adapted to the technological context. The Spanish Constitutional Court recognized the active freedom to communicate information, especially in favor to the media professionals, while the freedom to receive information is actually viewed as a passive right in favor of citizens. In other words, the Constitutional Court does not contemplate in this receiving dimension an active manifestation of information seeking, which is where, in my opinion, the right of access to public information should be configured, taking in account the international perspective. Unlike Portugal, which recognized the right of access to public information as a fundamental right linked to the political participation in the Article 48 of the Portuguese Constitution, in Spain, it's not recognized in this same line as a fundamental right. In Spain, the right of access to public information has been established as a legal right linked to the Article 105 of our Constitution, apart from freedom of expression and information in the Article 20. However, the fact that its connection with the fundamental right has not been appreciated by the Spanish Constitutional Court when configuring the nature of this right doesn't mean that this connection doesn't exist. This instrumental relationship between the right of access to public information and to the freedom of information has intensified with the development of the digital society and requires a revision in order to update the content of this freedom, the freedom to receive information in the digital context. And taking in account the social reality in which rights are exercised nowadays. In fact, this instrumental relationship has been confirmed in the framework of multi-level constitutionalism if we take in account the global perspective, the global level of the United Nations and the Council of Europe and the European Union. For example, in the global context, the Article 19 of the Universal Declaration of the Human Rights, and at the same time, the same article, Article 19 of the International Convention on Civil and Political Rights, provides for an active dimension of information seeking within the framework of freedom of information. And if we focus now in particular on the Council of Europe, the trend has been in the same line than in the global perspective. In this case, the European Court of Human Rights has interpreted the right of access to public information as a fundamental right when it serves as a democratic precondition for the effectiveness of the freedom of information in the frame of the Article 10 of the Convention. The European Court of Human Rights interprets the right of access to public information in the frame of this article, of the Article 10 of the European Convention, on the basis of the important case is the Meyer case in 2016, on a test of fundamentality based on 4 requirements. These 4 requirements are the purpose of the request for information has to contribute to the public debate. The second one is the nature of the information request has to be public. The third one is that the applicant acts as a social watchdogs within the aim of informing to the public. And the last one is that information has to be ready and available. In my opinion, these 4 elements adequately set the horizon on how to update the content of the communicative freedoms, in particular the freedom to receive information, the classical passive perspective of this right, to the digital society. In this sense, it's important that the evolutionary interpretation adopted by the European Court of Human Rights on the matter act as a roadmap for the member state. They must be able to integrate new realities linked to the digital society into their legal system, because they have a big influence to the effective guarantees of the rights. In conclusion, and with a specific regards to the right of access to public information in the framework of the multi-level constitutionalism, states must be sensitive to their interpretation in accordance with the international context. This leads to criticism passive positions such as the one currently held by the Spanish Constitutional Court in not admitting access to public information as a concrete manifestation of the freedom to receive information. And on the other hand, it reinforced the idea of the need to update the essential content of freedom of information in technological terms, obviously, in order to prevent the asymmetries of the current communication process. I conclude by underlining that digitalization is indeed a new multi-level public task in which the right of access to public information will serve as a democratic strategy against informational asymmetries. Thank you very much for your attention.
Thank you very much for highlighting a conflict of interest and constitutional values that becomes visible not only in Spain, but in many of the European constitutional orders, and where digitalization changes a little bit of everything. The traditional perceptions of our constitutional values are no longer what they used to be, and also for mentioning the interplay of the European Convention of Human Rights with national law. So we move on to our third presentation, which will be held by Rui Tavares Lanceiro, who is assistant professor at the University of Lisbon. His doctoral thesis covered the principle of loyal cooperation within the scope of public administration. He is also active as assessor, which I cannot translate, but I think there's no exact word for it, for the judges of the Constitutional Court. At least you used to be, you are still.
I used to be.
Yeah, okay, you used to be. Okay, but you at least never mind. So it's a part of, it's an important part of your curriculum after all. So your topic for today, so I'm sorry it didn't appear in the first version, but I think now it's inserted in the program. That was my fault, I think. It's AI and public administration, problems and opportunities to come. Please, the floor is yours.
Thank you very much. I also wish to begin by thanking Professor Vasco Pereira da Silva and the rest of the organization for the invitation to speak in this forum, and also to give me the opportunity to welcome you to our faculty and to Lisbon. Let me start by stating three cases. In Australia, a program was instituted to make it easier to check for fraud in Social Security by an algorithm that compared the supposed income of a person with the actual factual income, and that allowed for people to be automatically issued a fine if the values were not consistent one with the other. In Italy, the Ministry of Education used an algorithm to distribute teachers through the schools in the country. And also in the United States, algorithms are used to decide where police should patrol more or less streets because of predicted crimes that can take place in these parts of the cities. In all these three cases, we can see evolution in the administration. Public administration is changing as our lives are changing through digitalization, e-government, and in this case, particularly through AI. So this is how I wish to begin. This is the summary of my presentation. Firstly, what is AI? Then, is it useful for administrative decision-making processes? And then finally, problems and opportunities. It is easy to believe that we are facing a new industrial revolution, a second machine age that is revolutionizing the way in which we live and the way in which we behave and relate to each other and to corporations and the state and public administration. But the first question when we wish to check if artificial intelligence can be used by the administration in administrative decision-making procedures is what is in fact artificial intelligence. Then this is a very difficult question to answer because intelligence in itself is a very elusive term. When we think about intelligence, we basically think of something that is logical, rational, scientifical. However, this idea, this pre-thoughts about what is artificial intelligence or what is intelligence isn't really real, because this is not actually how humans think, how humans behave. In most cases, the most recent research in this field has reached the conclusion that humans are not very logical, are not very rational when they think. They think also with emotions. And that is something that is outside of the traditional field of what we think as intelligence. So this is also difficult when we are talking about artificial intelligence, because for the most part, when robots think, when algorithms think, they imitate humans, but they are unable to mimic this idea of feelings, of emotions. Hence also this idea, the Tesla theorem. Tesla was a computer scientist in Xerox that said that AI is whatever hasn't been done yet. So AI is something that probably was considered AI a couple of years ago, such as me talking with, an assistant in the telephone and mobile phone, and the assistant in the mobile phone helping me and writing messages for me probably would be considered something very intelligent a couple of years ago. Nowadays, it's something that we don't really think about. So AI is something that is perhaps by definition is something that appears in our heads, by definition, something that appears in science fiction films and not necessarily in our daily lives. However, it is something that is happening nowadays. Hence, this needs to confront the idea that the coding of the algorithms is something that is naturally different from human thought. So hence also this proposition that perhaps computers and machines are unable to be intelligent because what they do in most cases is basically mimicking what humans think that machines should do if they were to think as humans do. So they aren't really conscious. They don't really develop a consciousness. They don't really think. They merely mimic what the programmers think that they should do if they were to think. This is the reason why artificial intelligence is an elusive term, but also because it is a very broad concept nowadays. It includes identification, for instance, programs of facial recognition that can be used by the police, machine learning, testing and classification. For instance, the spam is a mechanism, is an algorithm. The spam that we receive in our emails is in fact the result of an algorithm program of testing and classification if we open those emails and so on. And also, finally, it can be simulation, deep fake, simulation of reality, simulation of a person in itself. So when we talk about AI, we talk about a very broad concept that includes a very broad set of tools that can be used by persons and by administration. But also, it is a very catchy marketing tool, because sometimes what we think is automation, what we think is algorithm automation, isn't really automation. Is in fact room full of underpaid workers in a room in India or in Albania or in Africa, classifying or doing the work that we think is in fact done by algorithms, because companies, corporations like to appear as they are very modern and using automation and algorithm as a problem-solving tool when they are in fact still using humans. So it is at the same time a very broad concept, but a concept that is still under development. Is it useful for administration? Well, it is useful, of course. It kind of is an instrument that can be used in very different fields. We've talked about social security. We've talked about policing. We can talk about also taxes. It has several levels of automation and several levels of autonomy vis-a-vis the person, vis-a-vis the human. It can be merely a supporting tool for human decision making. It can do the decision by the human, but include what is called a human in the loop. So finally, there is a human that actually checks the decision by the machine. Or it can be fully autonomous, deep learning, black box machine learning with complete absence of humans, what is normally more frightening. In terms of science fiction, it can also be an internal tool used by the administration, developed by the administration, or an external tool. And that adds another level of problems here, because that means that there is a private entity in the middle, there are patent questions, there are intellectual property questions, and that is one of the problems that most of the cases emerge. Not wishing to do any spoilers, the three cases that I mentioned were all three big failures of use of artificial intelligence in public administration. One of them, the Italy case, it's called the Buona Scuola case. The program was called Buona Scuola, was full of errors and mistakes. Teachers ended up being assigned to schools with errors of their resume of their CV, with ending up in schools hundreds of miles, hundreds of kilometers from their original hometowns. So it was a huge failure, and especially when teachers wished to see the reasoning behind that decision, they could not reach that reasoning because the machine did the decision. So it was impossible to see an actual reasoning for the decision, because also the machine did it. And when the teachers asked, can we see the algorithm behind the decision? The answer was the algorithm is patented. So it is impossible. It's a commercial secret. You are unable to see it. There is this problem, this additional layer of problems, if artificial intelligence is used as an external, as an outsourcing tool. For reasons of time concern, I will just skip this, but in this slide, you can see the several cases of AI. Once again, you have the data analysis, selection and evaluation. For instance, that was the case of the teachers in Italy. Resource allocation, it was also the central link, that was the name of the case, of the Australian case. The Australian case was also a very big failure because it basically, as we can imagine, the machine was more or less blind to differences. And also the data that was fed into the machine was faulty because the machine was comparing annual budgets with fortnights of income. So sometimes the income didn't check out because eventually during the year, people had fluctuations in their income, but the machine was unable to take that into account. So fines of hundreds of Australian dollars were issued, and people were very desperate because these were the most fragile portions of the population, the people that had to, in some way, dialogue with a machine that didn't answer, and in the end, ended up with huge fines that they were unable to pay. So in the end, the program was also scrapped. But this is another case then of one thing that is a problem, that is the machine learning is based on the data that is fed into the machines. Machines do not magically know everything. So if the data is faulty, the machines are also faulty, and the results of the machine is also faulty. The fact that code is commercial secret or patent is also a problem, as we've discussed in the Buona Scuola case, the Italian case. And also there are problems of digital literacy. We assume that people know how to speak code or to interact with platforms, with digital platforms. That is not normally the case in some groups of people, sometimes the elderly, sometimes minorities, sometimes the most in need of protection by the state. And those are the persons that in some cases are left in the hands of machines without really another way to relate to the administration outside of this idea of a machine. Of course, there are advantages of AI in public administration, the speediness, safety, efficiency, consistency. They always decide in the same way. It is a good idea to stop corruption, stop inequality, and also the only one's principle, in the sense that if we feed a data to the computer already knows this data. So it is not necessary to keep giving the same papers to different offices of the public administration. That particular computer already knows everything. However, there are these problems, and these problems lead to procedural rights that are also fundamental rights in peril, such as knowing the reasoning behind the decision, transparency and access to information. And in the end, if we have no reasoning, it is impossible to go to court and challenge that administrative decision. If the decision is taken by a private party, in some cases, in some countries, it is not considered to be a decision by the administration. So we have no proper way to review that decision that is not in fact an administrative decision in itself. The consistency that is an advantage can be also a disadvantage if it is a consistency of errors. If the data is faulty, we have a loop of illegality, of reproducing errors, and also the problem of also with the data that is fed into the algorithms, we have the problem of the reinforcement of bias. An American author talks in this case about weapons of mass destruction, in the sense that it reinforces bias against certain, for instance, racial groups or areas of the city. If an area of the city is more patrolled because police is racist, that area, more crimes are going to be found in that area because there are more police in that area. So that area becomes more and more known as a dangerous area. And if that knowledge is fed into the computer classifies that area as more police worthy. Then we enter into this loop. That is why, for instance, in GDPR, there is a specific Article 22, prohibiting this automatic decision-making profiling in this case. However, there are some exceptions, namely the possibility of a person to consent. And there's also this idea that what is forbidden is fully automatic decision-making. The human in the loop is not, if there is a human in the loop, there is no prohibition. But in that case, there is also an automation bias in the sense that the person, even if there is a human in the loop, the person thinks that the machine must be right. There is also Artificial Intelligence Act in the works by the Commission. And finally, just to finish, what I think is the future here is to take into consideration in this area of using artificial intelligence by public administration that the good old administrative principles such as equality, non-discrimination, proportionality, and transparency must play a role here, and they should be reinterpreted and applied still here. Due process is very important. So if there is an automatic decision making, due process rights must be fulfilled, and we must ensure that this instruments of artificial intelligence respect fundamental rights. Thank you.
Thank you so much also for your conclusions, and the fundamental question will be how to. This will be the challenge for the future. And so thank you for this insight into how to use AI and administrative procedure. I think that will, in 2 years from now, we will also have a SIPE Congress on matters of administrative procedure. And I think there the topic we will have learned some more things about the use of AI. So we now move to the fourth presentation, which will be by Giulia Ferrer, who is from the Università degli Studi di Milano, and the subject of her research and also of her doctoral thesis is EU law, and particular AI in its application to healthcare. And this is exactly what her presentation is going to be about.
Thank you very much. I'm using a timer, so I will stick exactly to the 15 minutes. As you may suspect from the title of my presentation, I am researching in healthcare law, and I am trying to carry out a comparative study on the digitalization of the healthcare system in Italy and Germany. Today, of course, I will just highlight two main aspects of the digitalization in the two member states due to the huge amount of information that I am actually facing. And my intent is actually to highlight the strongest point of Italy on one side and Germany on the other, because even if the two member states are very different, we have very different healthcare system. In my opinion, we can find some solution coming from both states, or complementary solutions, and this is what I will try to highlight. First, I take a step back and I wonder, why do we want more digital healthcare? Why do we want e-health? Well, it's pretty easy to say. At the end of the day, digital healthcare means better healthcare. because it can lead us to patient-centered medicine, which means more precise medicine, which is of great value, especially for chronic disease, so patient with chronic disease, because they get better quality diagnostic treatment and so on. Of course, also we have the possibility to access to digital tools 24 hours a day, 7 days a week. So digital healthcare is almost in certain parts always available for the patients, and we can gather good quality data and have an holistic view of the patient. Moreover, and I will show some data about it, digital healthcare is more cost-effective and time-effective. As you can see from this statistic, here it shows the distribution of healthcare professional time with and without AI. And we can very easily see that with the use of AI, physician and nurse and all the professionals can spend way more time in treating patients rather than in, for example, administrative tasks, Q&A, and transcriptions. On the other side, we need to wonder if patient trusts AI, if patient want to have digital healthcare. Here, the source is the European Commission, so I think it's quite reliable. And it shows us that, for example, in disease diagnostic, 89% of the patient trust the use of AI if it's combined with an expert judgment. 3% trust AI even if used alone. But in patient monitoring, 25% of the patient trusts the use of AI alone, and 69% if it's used in combination with an expert judgment. So I can say that, generally speaking, it's patient trust the use of digital tools, at least in disease diagnostic and in the patient monitoring. So my question here, and it's what I'm trying to figure out also during my dissertation research, PhD research, is how can we maximize the potential of digital healthcare? And I can identify two pillars. On one side, to make available good quality data, both for the patient and for the physicians. And this is what we can reach through the electronic health records. And it's the strongest point from Italy, relatively stronger. And on the other side, we need to integrate the mHealth into the national healthcare systems. mHealth is mobile health. It's all the healthcare that is provided through apps, smartphone, wearables, and sometimes also personal computer. And this is the strongest point for Germany with the Digitalversorgungsgesetz. So these are the two tools that I am comparing. As said before, Italy and Germany are two very different member states. Also, the healthcare systems are very different, with Italy having a universal system on a Bavarian models, and Germany has a Bismarckian system, insurance-based. Germany is, as we all know, a federal state. Italy is not. But actually, we are facing the same problems, and we are finding different tools to face actually the same challenges. So what I try to do at the end of the work is to highlight the strongest point and to outline a model that could be useful on the path of a digital healthcare system. So I searched from the electronic health records, Fascicolo Sanitario Elettronico. What is it? It's an online tool that gathers all the data of a patient, so the reports, prescriptions, appointments, and so on. And all these data are visible both to the patient and the physician if the patient wanted to be visible to the patient. So this is mine, so no worries about sensitive data getting spread around. This is what must be in every electronic health records. In Italy, it's on a region base, so every region has its own model, but all the electronic health records must contain the report, so the result of the exams and so on, and the prescriptions. These are the most important parts of it. Moreover, every region can implement also other aspects, like the next appointment, the payments, and so on. One can worry about its privacy of the patient and the control over the data. And this is actually solved by the fact that the patients have the control over his or her personal data and can choose whether to make the reports visible to the physician or not. We can see that the implementation, it's quite homogeneous in all the Italian regions. Most of them have 100% implementation, meaning that the software is there, the infrastructure is there. Some regions are around 80%, meaning that they are offering 80% of the services that can be provided through the electronic health records. But let's say that from the implementation point of view, from the infrastructure point of view, so administrative part, it's, I think, in my opinion, quite satisfactory. While we have a problem about the use of the electronic health records by the physician, because as you can see, some regions are around 100%. So all the physicians, all the hospitals are using it, are feeding the data into the electronic health records, but there are some that are not using it. So every patient has electronic health records, but the physician are not feeding the data into this electronic health record. So we have actually a problem of territorial divide, which can also be caused by the fact that the first law on the electronic health record leads us back to 2012, but not all the regions have developed it in the same time. So in the center and south of Italy, it has been developed later. And this could be probably one of the cause of this territorial divide. So I hope that with the new guidelines that have been adopted in 2022, a new regulation, the situation will change. Also, Germany knows this tool, the Elektronische Patientenakte, but actually the implementation is quite weak. And also it's a pretty new tool, actually introduced in 2021. Just 6% of the physicians all around Germany are using it. Some say that they are willingly to using it, but they do not have the skills, or the patients do not want them to use it, or they just don't want to use it. But the biggest problem is the number of the patients having electronic health records, which is just 1% of the German population. The Elektronische Patientenakte adopted a opt-in system, so it's completely up to the patient to activate one, and so just 1% of the German population have done it now. About the causes that I have highlighted, the procedure, it's quite different. One of the main problem, in my opinion, is that in Germany, it's an opt-in system and it depends on the insurance fund. So every insurance fund can have a different electronic health records. And now also it's possible to activate it through apps and smartphone, but few months ago, one of the possibility was to go physically to the physician or to the insurance fund to make it activated, which could cause some problem, especially if we think in the COVID time or something like that. But one of the other problems is the concerns that the German population has about privacy and data security. Most of them do not want to put all their personal data, so sensitive data as healthcare data, online, and to make it available to not only the physician, but actually being an insurance-based system to private insurance as well, that can evaluate the risk of the patient differently once they have really all the data that they can get. Now we come to the strong point of Germany, because this was the bad part for the German, but with the Digitalversorgungsgesetz, Germany adopted actually a really pioneering law on mHealth and on eHealth. It introduces, it's a law from 2029, modifies the Sozialgesetzbuch 5, and introduce a large-scale reimbursement system for apps and wearable devices that fit in a list which is held by the Federal Institute for Drugs and Medical Devices. And if they are used in accordance with the prescription of a physician or a psychotherapist, or in agreement with the insurance fund. So if you have the prescription of your doctor to use a certain app, for example, you are a chronic patient, you have diabetes, you got the prescription for an app for the treatment of diabetes, this will be reimbursed by the insurance fund. Of course, there are some requirements that need to be met in order to fit into this list. First of all, it must be a lower risk medical device according to the medical device regulation. There are a lot of apps that looks like a medical device, they perform like a medical device, but they are not approved as medical device. So this app cannot fit, of course, into this list. They need to meet some safety and functional capability. Of course, some data protection and data safety and security requirements are there as well. Moreover, the manufacturer needs to prove the positive effect of the use of the app for the patient. Of course, most of these apps are for, as said, chronic patients. So the proof cannot be the recovery of the patient. That's not the task of the app, of course, but the use of digital tools can improve the quality of life of the patient, can make easier, for example, to take medicine, to register data, and to just carry on everyday activities. So the manufacturers need to prove this positive effect on the patient's care in order to be admitted and to be adapted for reimbursement. Some relevant aspect, these apps are directly provided to the patient, which will not pay anything because it's reimbursed by the insurance fund. If we are talking about the mandatory insurance, like the gesetzliche Krankenversicherung, and it can be bought or can be provided through a third platform like Google Play Store, Apple Store, which are platforms that we are very familiar with. We use them almost on a daily basis, so it's nothing strange for a patient to use. This reimbursement system can help us cope with the economic exclusion, which is one of the biggest topic when we talk about the digitalization of healthcare and of public services, because economic divide probably will need to face and to deal with. At the end of the day, just the reimbursement actually of apps and wearables, I am afraid it will not be enough if we do not consider the fact that we need to also provide some reimbursement for the hardware like smartphone, computer, and so on. Otherwise, the weakest part of the population will be left out. We will be back to some kind of two-class medicine for those who can afford it and for those who cannot. The goal at the end is an integrated e-health system, because starting from this year, the Digitalversorgungsgesetz asks for the interoperability between the apps and the data that are gathered there and the electronic. We have seen before, but the electronic health record is almost not implemented. So this provision is actually no effect if we do not start before with the implementation of the electronic health records in Germany as well. So these were just some food for thought and some highlights on the two parts that I am considering in my research. And I think that at the end, if we put together the two models, we can get to something good on the path to digital healthcare. Thank you.
Thank you very much for this comparison, and you'll see that so there is a cleavage in the digital reality of Europe, even though the GDPR wants to create a level playing field. And thank you for also talking about digital culture, which matters very much. I also learned quite something about Germany and the background. But this is a revolution that's taking place after all, and Germany cannot halt it, despite its reservations on the use of digital things. So we're now coming to the fifth presentation, which will be by Miguel Arjona Sanchez, who is assistant professor of constitutional law at the University of Granada. He has a remarkable number of degrees from both Spain and the UK. The doctoral thesis he wrote was on the freedom of capital in Europe, and his current focus is on the monetary union, especially on digital currencies, the true ones and the so-called ones, I suppose, and this is his subject for today. Give the floor. Sorry.
15 minutes.
Thank you very much for having me. It's a pleasure to be in this prestigious Congress. I'm gonna speak about the digital currencies, challenges and opportunities for public staff. This is the title of my dissertation. Obviously, I'm going to speak about this kind of money, digital money. First of all, I have to express that it's not simple to define what means money. There are different point of view, different perspectives. Most of them, they are very, very ideological. There are scholars who think that money is a private thing, and others think that it's something public, created by the state. My dissertation will be divided into different parts. The first part is dedicated to cryptocurrencies. It's the most famous money, digital money in the world. But we are going to criticize this kind of cryptocurrency because, in my opinion, it's not money. There are no money. And then the second part of my dissertation, we are going to speak about something very, very important for the future, very, very important for the public staff, that are the central bank digital currencies, digital fiat money. Well, we start with the first part of the dissertation. What are money? It's not easy to, as I've explained before, it's not easy to define what means money. But we know there are three different characteristics that everyone is agree that are the characteristics of money, the functions of money. Is unit of account, means of payment, and value deposit. A cryptocurrency, you know that the most famous cryptocurrency in the world is Bitcoin. Everyone knows. It's the Bitcoin or another kind of cryptocurrency, more or less, are very similar. Are really money? Well, the first characteristic, means of payment. Bitcoin or other cryptocurrency is not really a generalized means of payment. It is true that you can buy something by Bitcoins, but it's impossible to go to a supermarket. You do your buys by Bitcoin or another cryptocurrency. You have a limit market for use this kind of cryptocurrency as a means of payment. It's an unit of account. Well, it's not a unit of account because prices are not expressed in cryptocurrencies. It's a consequence of the first characteristic. It's just the opposite. You can know how is the value of Bitcoin in euros or in dollars or in another real currency. And the third characteristic is a store of value or a value deposit. It is. And it's because the success of this value deposit that is impossible that it's difficult to manage the kind of cryptocurrency, but because they will produce deflation. I'm going to explain that slowly. Most of the cryptocurrency are part of a vision of money that we can define like private money. You know that libertarians love this kind of currencies, and they have nostalgia for the gold. This is the cause because they are defining this kind of money by a characteristic very important, scarcity. For example, Bitcoin have a maximum number of Bitcoin that will be produced in the world. And this is the characteristic that do the cryptocurrencies like very important deposit of value, but ineffective money. This is very simple to understand. If you have a scarcity of money, if you have some interest in this money, the value of the money will increase in the time. But if the value of the money is increasing, every day have more value, what you will do with this money is keep your money in your wallet. You don't go to a supermarket to buy something if you think your coins in your wallet will increase your price. And this is the reason because this kind of cryptocurrencies produce deflation to understand. And this is the principal problem of this kind of cryptocurrencies. They produce deflation, and it's part of what we call the casino capitalism. There are some countries that do some experiments in this kind of cryptocurrencies. The case of Salvador is very known. And we can see how it's difficult to manage this kind of cryptocurrency because basically they are not stable. It is true that there are some experiments to create stable coins, cryptocurrencies coins, sorry, but central banks are fight against this kind of cryptocurrencies because the sensation that they represent some kind of competition, illegal competition against the financial system. And the second part of my dissertation are about the central bank's digital currencies that are real money. We can call too the digital fiat currencies regime or digital fiat currencies. 87 countries in the world, which represent more than 90% of GDP in the world, have a project to create a digital fiat currency. So we can be agreed that in the future, we are going to manage this kind of new currencies. There are different models about the digital central bank currencies, central bank digital currencies, sorry. We have at least 3 kinds of models. We have a very centralized model, which the central bank manager all transactions in real time and keeps a record of all retail holdings. There is another model, more decentralized, in which transactions are recorded by financial intermediaries and then reported to the central bank. And then we have also a hybrid model about these new currencies. But to understand what means this kind of currencies for public tax, it's important to understand how these currencies represent a revolution in the financial system or for the financial system. We have to ask new questions about the rights of privacy or anonymity. We have the possibility to increase tax evasion, prevention of money laundering, illicit activities. But this is only a small part of the revolution. I'm going to give you only a small example that I think can express the kind of revolution we have to face. The most simple financial operation in the world is to do a loan, to get a loan. Most of the people think that the banking system is an intermediary between the deposit of in the bank of their clients and the loans. But that is not true. That is not true. In fact, what the private banks do is create money. They create money in a framework created by the state because the real function in the market is analyze the kind of asset will back this loan. This is the real function of the private financial system. Contrary to what most of the public believe, banks are not exactly intermediaries. They loan, they deposit money. I'm going to try to explain how that works. Loans create deposits. No deposits create loans. This is the real way that the financial works. The function of the banking system is to provide liquidity to the market and to have a transparency and more perfect market, evaluating, analyzing the collateral assets that a client have to do to the bank in order to obtain a loan. This is the real function of the financial system. But what happened with the digital currencies backed by the central banks? Most of the scholars agree that we are going to see how deposits round from the bank deposits to this new money. So what happens if the banks want to have more deposits of their clients? We had to invent a system to create loans without deposit. This is not very difficult theoretically. This is not difficult theoretically. We are going to see how, for warrays, the situation is more or less the same. The only difference is they will have money with safety, because they will have not only a deposit guaranteed by the bank, but by the central bank, the real money. Each of the citizens have to have an account, bank account in the central bank. For the lending bank, the situation will be more or less similar, but in another framework, in another legal and technical framework. But the real transformation is the transformation for the financial system. If a bank will create loan without a deposit, it's because the central bank will authorize this kind of operations. It's more or less the same what we do now. But the difference is that the interbanks market will disappear. If we don't need more a market between banks, the situation has changed, absolutely changed. Why? Because we are going to have a more safety financial system. Shadow banking will disappear. And we are going to eliminate a lot of some of the real problems that the casino capitalists are representing in this moment for the financial systems. This is only an example of the transformation of this kind of currencies they are going to face from the next years. There are more. For example, fiscal policy. Let me explain what means fiscal policy. Most of the people believe that a state needs the fiscal policy to obtain resources to spend their policies, but it's not true. A country with monetary sovereignty creates their money. The real function of the taxes is kill money and drive the economy. It's very simple to understand. We create money, it's the central bank who backs the creation of money directly by the state or by the private bank. And then you need to kill money in order to limit the quantity of money they are in the market. And obviously, because you can tax some activities that the state don't think are interesting for the state. For example, you tax an industry because they create pollution or whatever, other circumstances. But if we have an intelligent, a digital money, a digital currency, we can have a different fiscal policy, because it's a kind of tax system in order to keep money. We are going to know where is the money of a market. And obviously, a second very important economic law in the money, we can face the possibility to have our money with different aims. Imagine your salary will express some quantity of your salary will be available for buy everything, another, for example, only for cultural goods. This is something possible because we're going to see a new system more intelligent. At the same time, the possibilities of organization of the market, what we call planification, will be great. So we are going to face an absolutely different financial market. What is the real importance of these kind of things? The important real kind of thing is it's possible to face a new revolution in the financial system. It is true that will be difficult because people will understand for the first time how the financial system works, as it's not something that will limit in some countries. Today, it's news of today or yesterday, not sure, I think it's today. The chairman of the International Monetary Fund recognized that they are working very, very hard to create a bank central digital currency platform in the world for all the countries in the world, sorry. So we are facing a revolution that will facing or the object of this Congress, public task. And that's all. Thank you very much for your attention.
Thank you very much. So we're indeed facing many revolutions, and what started at 0 and 1 brought us to a colorful new world, even in the legal realm. And so if I understood you correctly, so this is something, the digital euro will also be something like the unofficial 4th pillar of the banking union, in that the intricacies of the interbank lending that aggravated the fiscal crisis will not be there anymore. But the problem we are facing is that the president will be knocking at our door very, very early, and so we must make a short intermission before. So we need to terminate at 5:30 sharp. So I'm afraid there will not be a very long discussion. So, and what is now following it will maybe not being worthy being called a discussion, but we have room for a few questions and remarks. So without further ado, who wants to address? So I'm not attempting to summarize these 5 very diverse contributions, each of which was, I think, very inspiring and thought-provoking. Yola Schmidt. Do we have a microphone? So because we have some persons that are attending on video, so otherwise they will not hear the questions. Otherwise, I can repeat the question.
First, why didn't you refer to the definition of the proposal in the AI Act, the Act, and balancing methods, and so on? Second question, why did you miss out on birth judgment or decision of the European Court of Justice regarding AI PNR decision? Please give
questions. That's better.
Italy, we were talking about that they have a different position, and that is that which is the better part. The second part is I wonder when we say Germany is hard and all up the president
About the first question about Statista, actually this data were, I used the diagrams, but they are data from the European Commission. So I thought that as a source, it could be quite reliable. I just needed some diagrams to use for the PowerPoint, and Statista had good quality visualizing visual diagrams. About the second question, I'm not sure that I mean I do not mean that Germany is behind or anyhow, because actually on a part on e-health and so on, I I'm pretty sure that it has a pioneering legislation on that. I'm not sure that there is any other member state with that kind of legislation, except maybe for Finland. Belgium, thank you. But as a matter of fact, the development of the Elektronische Patientenakte is only 2 years old. So it will take time. It's also physiological. Even Italy has developed it in 10 years. So I just think it will take time because it's a good legislation also on that point. About if I recall correctly, the second part was about the trust of the patient and the security of the data if something happened.
Who takes care of his or her e-health? Yes.
I think it works like it should work without the digital technology. I mean, in Italy, we should, if a patient is not able to take care of himself or herself, the judge will nominate a tutor that will take the decision for him or for her, and it will be the same even if we are talking about e-health and data. The tutor will have access to the electronic patient records and so on. I think it will make no big difference in the e-health field.
Right, to some of the questions?
Yes.
Okay, so thank you very much. Sorry. You were there. Okay. Thank you very much. In terms of the first question, in all truthness, because of so the two questions were, why didn't I in terms of definition of what is AI, what didn't I use the definition in the Commission's proposal for an EU AI Act? And the second question was, why didn't I address the recent decision by the Court of Justice on this matter? The shortest and simplest answer is for lack of time. In terms of also the definition of AI, also because I do believe that during the negotiations between Parliament and the Commission, I believe that there can be some changes in this matter. So I do not think that the definition as proposed by the Commission will be ultimately the definition of the legislation. And also because, also in all truthness, because I wanted to give the public the idea of the elusiveness of the definition. If I did probably wrote too much in my slides. Eventually, I would go to the proposal of the EU AI Act proposal, and I would talk a little bit about it, namely because also the Commission is very also worried, or in the proposal talks about not stifling the use of certain types of AI tools by the public administration of member states, trying not to hinder the development of the technology by the member states, I believe. And I think also that would mean some changes, or probably some changes in the definition of AI. That is also the reason I also wanted to do a more general presentation on the topic. So for lack of time, I did not mention the court decision. Thank you for your questions.
Thank you.
Can I ask a question? No.
Yes, with 5 minutes left, but you have a question, so no one else raised their hand. So
No. Okay.
please.
I will be very short, and because I enjoyed all the 5 presentation, but one sentence concerning the e-health. What I would like to suggest you that 3 days ago, the Belgian Constitutional Court annulled the Belgian law exactly for the considerations which we heard from you concerning its compliance with fundamental rights. So I think for you, it will be extremely useful to read the ruling of the Belgian Federal Constitutional Court. The second, if from Milano, I would suggest you to have a definition on rule of law, because using the term of rule of law today, you must have some caution, because we have no definition under EU law, but maybe concerning your subject, that definition could not be really applicable. So I would suggest you to have a kind of definition when you refer to rule of law. And concerning Artificial Intelligence Act, I can assure you that there will be plenty of amendments to the Commission proposal. Thank you.
Very briefly, actually a question for the audience. So everybody, we are holders of our own health data, right? And the European health data space will allow for better access and portability and cross-border use, primary and secondary. This is the two, both uses, primary and secondary, are present in the European health data space. Question: aren't we supposed to get paid as holders of that data, health data? If our health data is going to be used by researchers, for example, shouldn't these subjects, these data subjects, these patients be also paid for the specific use?
This is a good question, so it's wise not to address it because it's so good. Answers to the ones.
Very much for your appreciation. I will take note about it. It's just 15 minutes, so I have tried to share some reflection about the topic, but I know that it's possible to concrete more the concept to the rule of law and at the same time to the democratic principle. The relationship between the principle of transparency and the rule of law in this context, in this topic, or what I try to reflect about it, it was that transparency permits to the citizenship to connect to the public sphere. So at the same time to know how public authorities take the different decisions. So it's reinforce the idea of the rule of law, I think. Thank you.
I got the question about the European health data space and so on. I don't know if I agree about paying for data according to the non-proprietary vision that we have about data. I just want to underline my skepticism about the European health data space and the possibility to reuse personal data for research, which is not it can be also private research, can be also for private entities. And I think that that kind of regulation can a little bit jeopardize the GDPR purpose of and system. I do not know if you agree with that, but we can also discuss it later.
I agree, but we have a very aggressive moderator, so we need to stop.
Okay, if you say so, but we have a we have a very aggressive protocol of the presidential office in Portugal. So the president shouldn't come in and see us as we are here discussing. So we must make the intermission now, therefore. So So this means we have a small break. You have a small break to discuss some issues a little bit further, and we'll go outside and wait for the president. Thank you, and join me in the applause for the panelists.